Five, four, three, two, one.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon, gentlemen, and welcome to the Court of Appeals. We appreciate you agreeing to participate in this oral argument via Zoom. I want to tell you that we do not anticipate any glitches of any type, but if we experience any, we'll get those taken care of, and you will not suffer because of any of those. Also would like to take this opportunity to remind you that we will be operating under the same procedure, the same protocol as if we were all in court together, which essentially means each side will receive 15 minutes to make its oral argument. And if the appellant has previously reserved rebuttal time with Mr. Hibner, you will receive that time as well. Before we get started, I want to take this opportunity to introduce your panel for this case. I have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case.
The State of Stella Ruth Hughes et al. Versus C. Ray Adams et al.
And we will hear from the appellant.
Thank you. My name is Scott Reams. I represent the appellants in this matter, a member of the Hamlin County Bar. I have asked Mr. Hibner to reserve 5 minutes for rebuttal for us.
All right.
A little bit of background on this case might be helpful. I'm somewhat of a Johnny-come-lately, as I did not represent the plaintiffs in this matter when the suit was initially filed. The underlying lawsuit is one for accounting malpractice growing out of the preparation of some estate and inheritance tax returns. What is here on appeal involves an alleged settlement agreement and a motion to enforce that settlement agreement. The defendants or their insurance carrier had paid $300,000 toward the plaintiff estate's supposed federal estate tax liability, and the plaintiffs themselves had paid $127,000. They had also paid $390,000 in Tennessee inheritance tax. The lawsuit was filed, initial lawsuit filed March 10th, 2015. Following the payment, the plaintiffs employed some tax professionals to try to get the amount of the tax lessened or refunded, and they were successful in doing so. The IRS issued a notice of refund for $101,875.11 on December 26, 2016. The defendants then filed a motion for summary judgment in June of 2017, claiming that refund was theirs because of the payment that they had made toward the tax liability, and sought a dismissal of the action. That motion for summary judgment was noticed for a hearing on July 18 of 2017. Now, on June the 9th of 2017, the plaintiffs were having some disagreement with their attorney, Mark Jindrek, and he notified them that he would be withdrawing as their attorney. Mr. Jindrek discussed this with Mr. Brown and as attorney for the defendants, and Mr. Brown encouraged Mr. Jindrek to stay in the action until to see if they could try to negotiate a settlement. Mr. Jindrek eventually did file a motion to withdraw, and it was noticed for hearing on July the 18th, 2017, the same day as the motion for summary judgment was noticed for a hearing. Now, the trial judge criticized Ms. Dawson for shopping her case, but she really was doing about the only thing she could do faced with a motion for summary judgment and a motion to withdraw. What happened thereafter, if we look at the trial, the proof at the trial mainly consisted of the testimony of Mr. Greg Brown, the attorney for the defendants, and Ms. Dawson, the plaintiff. They were the only two live witnesses. And after hearing the testimony, the trial court found that Ms. Dawson had authorized her attorney to enter into a settlement agreement, but then had withdrawn that authority by sending Mr. Jindrak a text message. What had happened on July the 14th, Mr. Jindrak, on behalf of the plaintiff, sent a letter or an email to Mr. Brown saying that his client might be interested in entering into a walkaway settlement. This was at 3 o'clock or 3:15. This had followed a meeting that Ms. Dawson had had with her attorney, Mr. Jindrak. She then talked to me. She had talked with me earlier, several days earlier, and I told her I could have to check conflicts. And she called me back and I said, yes, I can review your case for you. She then texted Mr. Jindrak, her attorney, to tell her I had agreed to hear or at least evaluate her case, and wanting him to hold off on any settlement agreement or settlement negotiations until I had a chance to review it. Subsequently, about an hour after that text message, and Mr. Jindrak, there was an affidavit acknowledging that he received a communication from Ms. Dawson to that effect. About an hour later at 5 o'clock, Mr. Brown called Mr. Jindrak, and they were discussing it. And Mr. Brown asked Mr. Jindrak, is that an offer? And Mr. Jindrak at that time said, well, yes, I guess it is. The trial court found that Ms. Dawson had authorized Mr. Jindrak to enter into settlement, walkaway settlement. Ms. Dawson denied that she had, but the trial court resolved that issue against Ms. Dawson. The trial court also found that the text message that she sent to Mr. Jindrak revoked her authority, revoked his authority to settle the case. And this was at 3:45, and the subsequent conversation showed that there wasn't even an offer until 5 o'clock. But the court also found that the case was settled prior to the text message being sent. We think that is clearly erroneous, and I think even the defendants agree that there was no offer on the table at the time that text message was sent at 3:45 on July the 14th. So that what we have is the trial court misapprehending the facts. There was could be no settlement because Mr. Jindrak, her attorney at the time, had no authority to settle the case. He had no express authority, as that had been withdrawn. And in Tennessee, there is no apparent authority for an attorney to settle a case for a client that involves a dismissal of the claim. Even under the restatement of agency, there was no authority. The restatement basically says that if a agent's authority is revoked when there are circumstances known to him that would indicate that his authority would be revoked. Here, Mr. Jindrak knew he had filed a motion to withdraw. He also knew that his client was looking for other counsel, and by his own affidavit admits he had received a communication that she had obtained another attorney to review her case for her. Therefore, the authority for him to settle this case did not exist. He had no apparent authority. He had no actual authority. He could not bind Ms. Dawson to a binding settlement. If you go on and look at the other side of the equation, there was no testimony other than Mr. Brown's testimony that he had authority to settle this case. None of the named defendants testified. No one from the insurance company testified that he had authority or what they were entering into. And in fact, that leads into the discovery dispute that we have involving emails. Now, it's important to note that the emails that are involved in the discovery dispute between the Mr. Brown and the insurance company or whoever it was were not introduced at trial. There was nothing at trial that would show that Mr. Brown had authority to settle for any of the defendants or any of the parties that were required to execute a settlement agreement. And the law in Tennessee is that the agency cannot be proved solely by the testimony of the agent. So there is simply no proof in the record that the principal of the defendants gave any authority or in any way consented to this settlement agreement. Going on to the discovery dispute, and I think my time is about up, so I will stop for that and address that later.
All right, sir. Thank you very much. We will hear from the appellee.
Good afternoon, and may it please the court. I'm Greg Brown of the Knox County Bar. I represent the defendants and appellees in this matter, who are accountants for the plaintiff. The issue here is whether or not the court correctly enforced a settlement agreement that was now entered 4 years ago, by which my clients paid $300,000 to the plaintiffs. That payment resulted in a refund to her of $101,000, and that created a situation in which we had competing claims. The plaintiff was potentially seeking more money. My clients were seeking recovery of the $101,000 that they had overpaid. And in fact, my clients, as Mr. Reams correctly noted, had filed a motion for summary judgment seeking recovery of that money. And that was the context in which settlement negotiations were entered into. There's a complete record of lengthy and extensive settlement discussions. There's a June 22nd, 2017 email about a potential settlement. June 23rd, Mr. Jendrick, who represented the plaintiff appellant at that time, said he would hold off on withdrawing to see if he could help settle the case on her behalf. July 7th, he emailed and said, I remain hopeful that it will settle. And on July 10th, in the record is an email from me to my clients, who consist both of my clients and their insurer, and in which I memorialized the ongoing discussions regarding a walkaway settlement, in which my client would give up its right to recover the $101,000 that it had overpaid, that had gone into the plaintiff's pocket, and the plaintiff would give up any argument for additional damages. The settlement was reached on July 14th, and it began with a phone call at 1:31 p.m. in which Mr. Jendrick, on behalf of the plaintiff, said that he was going to meet with her and recommend a walkaway settlement. There was a voicemail at 3:10 p.m. saying that he had spoken to her and would send an email. At 3:15, he emailed and said, I think she will go for a walkaway. And if we do not talk later today, hope you have a great weekend. This was July 14th. July 18th was a hearing on our motion for summary judgment to recover that $101,000. At 4:41, Mr. Jendrick called and said that that the plaintiff would do a walkaway settlement where each party gave up their claims against the other.
Mr. Brown?
Yes.
The trial court made a finding that the case was settled before 3:50 on July the 14th. Upon what did the court make that finding? Upon what proof?
Your Honor, I don't know at that point. The communications were clear. The emails, the timestamps on the emails are clear. And I think that the court made that finding ultimately based upon a credibility determination regarding the plaintiff, significant questions regarding the authenticity of this purported text message.
And did the court make an explicit credibility finding as to, I believe there were two witnesses that day. I believe you were one of them, and
Yes.
then the plaintiff. Did the court make specific credibility findings as to either of the witnesses?
Yes, it's in the record. Transcript of evidence, volume 3, page 86. And this is, I'll tell you what the court said. He said, I guess one other thing I would observe is, the court believes that a lawyer never has apparent authority to settle case. It has to be express authority. And I find specifically, if there's any doubt about it, that Mr. Jendrick had the express authority to settle the case. Else she, meaning the plaintiff, would not have felt the need to tell me from the witness stand that she specifically texted him and said he didn't have that authority. So the court believes very strongly that he had the authority. It's hard for the court to reconcile her express testimony under oath that she didn't give him that authority, but the court is going to try to be benevolent to her and find that that's from a failed memory of things that happened several years ago and not out and out false testimony. I think she's an honorable lady. This case has been in my court for a long time, and I think she's had some other cases, but I've never had any trouble with her. I think she's a fine lady, and I'm accusing her of being mistaken and not being false to the court. And
you consider that to be a credibility finding as to the plaintiff's testimony?
I do, yes. I think he clearly found that her testimony did not have weight, and credited that to a failed memory rather than an intent to give false testimony. And since the court is asking this question, I'd like to talk a little bit about this purported text message. And I need to call it that because the circumstances under which it came up in this hearing were extremely suspect. By the time of this hearing, this issue, enforcing the settlement agreement, had been in litigation for more than 2 years. The motion to enforce the settlement agreement was filed 2 years before. There had been briefs, there had been affidavits. This text message was never attached or submitted to the court in any of those. Mr. Jendrick gave a deposition, and in his deposition, he described, he confirmed his understanding or his recollection of the facts, which did not include receipt of any text message. On the August 23rd, 2017 email from Mr. Jendrick, in which he recounted what had happened, he said, Linda and I had a telephone conversation in which she said she was good to go with a quit and walk away settlement. I then called you and said that Linda had agreed. A couple of days later, I received a call from the fellow in Morristown who said that Linda wanted him to have a look for her. And I reiterated to him that as far as I was concerned, Linda had made a deal and I had passed that deal along. I called Linda and told her the same thing. And I've not heard from either of them. So nowhere in this is there any mention of this purported text message. The text message was introduced at the hearing after all of the witnesses were off the stand, after Ms. Hughes was off the stand and could not be cross-examined about its authenticity, after it was clear that Mr. Jendrick would not be on the stand at all and was not going to testify. And as the court was leaving the bench, they handed this email to him. And that was our first notice that this text message existed. And when you look at it, it's not a text message. It's a text message. It's a picture of a text message with a little heart emoji on it attached to an email from the plaintiff to the plaintiff. And there's sworn affidavits concerning what happened after the hearing that we asked to see this text message. She said it was on her phone. And then it was not on her phone. She could not find it. We served a subpoena on Mr. Jendrick asking for his text messages with her, and the plaintiff filed a motion to quash that subpoena. And that issue was never resolved because the court granted the motion to enforce the settlement agreement before we had a chance to explore it. So this is a text message that was not in any discovery, was not in any briefs, was not submitted to the court, was not available. It's not made available until after nobody could be cross-examined with it. was not on her phone, even though she had said it was. The origin, the authenticity of this text message are all of the facts surrounding it are significant in drawing into question its authenticity. So it's clear from the restatement on agency and from law in Tennessee that revocation of authority is not effective until it's received by the agent, until the agent has knowledge that his authority is being revoked. And there's not a shred of evidence in this record that Mr. Jendrick received that purported text message at any time. Was he aware that she was?
Let me ask you a question.
Yes, sir.
At the time that you submit that this case was settled, what was the testimony of the appellant regarding the authority that her former attorney had? What is her testimony about how things had been left?
Her testimony was, I think she said that she had never given Mr. Jendrick authority to settle the case, and the court made specific findings regarding that testimony. Because it's
what did the court say about that particular testimony?
Well, at the bottom of page 84 in the transcript of evidence, volume 3, there's another part of the language of the text message that Ms. Hughes Dawson sent Mr. Jendrick that flies in the face of her own testimony, and that is that she never authorized him to settle the case. It's clear from her wording in that text that they had talked about settling the case. I mean, you can read the text and tell that she was anticipating that the case would be settled, except she wanted to give Mr. Reams a chance to look at it, apparently. And if you back up, it says, I've read the affidavit, Mr. Jendrick, but I guess most importantly to the court is I've seen the emails that were exchanged between Mr. Jendrick and Mr. Brown contemporaneously with this alleged settlement. When I say settlement, I mean quote unquote settlement, period. But it seems very evident that for a few minutes the settlement was reached. And I'm sorry, I don't want to waste the court's time by scrolling through this transcript, but it's all in the range of approximately page 75 to 85 of the transcript.
Well, I guess what I'm trying to get in my mind is, at what point did the court determine that the appellant gave her former attorney authority to settle the case? Because all this seems to be equivocal at best, or open to interpretation between what was said and what was heard.
Well, I think the what was said and what was heard part regarding the terms of the settlement, the court made a finding that a walkaway settlement is in the context of these circumstances is clear enough. Each party was
I'm not talking about the substance of the settlement. I'm talking about the authority.
Yeah, again, so I think if you go back to July 14th, 2017, again, there's a phone call from Mr. Jendrick at 1:30. I'm going to recommend this walkaway settlement. 3:10, I spoke to her and I'll send an email. 3:15, I think she'll go for a walkaway. If we don't talk later today, have a great weekend. 4:41, walkaway, she'll do the walkaway. Is that an offer? Yes. Now, at no point, whenever he met with,
and let me stop you right there. That's at 4:41.
Yes.
What was the testimony of the appellant, and what was the testimony of her former attorney that transpired prior to 4:41? I'm just trying to get all this straight in my mind.
And I think the best source for that regarding her attorney is in his deposition. Exhibit 3 to his deposition was the email that he sent on August 23rd, 5 or 6 weeks later. And that was in the context of that was that was the first time that, we'd already prepared the written settlement agreement to formalize it. And he sent an email saying she's gone to a fellow in Morristown who worked for her father to figure out whether this is a good solution for her. And I replied to him in this email and said, I understood from our last phone conversation that Ms. Hughes had agreed to a walkaway, which is why I prepared the draft agreement. Is that not the case? And he responded to that, which I'll read to the court momentarily. But in his deposition, he was asked, are these, when you wrote this email, was this true? And he said yes. And so this email written by Mr. Jendrick on August 23rd is the best evidence, or as close to we have as we have to contemporaneous evidence of that sequence of events between Mr. Jendrick and the appellant, which is we had a telephone conversation in which she said she was good to go with a quit and walk away settlement. I then called you and said that Linda had agreed. A couple of days later, I received a call from a fellow in Morristown who said that Linda wanted him to have a look at it. And I reiterated to him that as far as I was concerned, Linda had made a deal and I had passed that deal along. So I think that email from the appellant's attorney describing that he had a phone call with her, she said she was good to go with the walkaway settlement, and he communicated that to me. That's the best evidence we have regarding what happened there. Again, the court made a credibility determination regarding the appellant's testimony that she had never given him any authority, and also the text message that, as far as we can tell, was never on her phone. I know I'm out of time, unless the court has any more questions for me.
Mr. Brown, at what point, what date, what time did you communicate to Mr. Jendrick that your client was accepting the walkaway offer?
The following Monday was when I had communications with my clients, in which they all agreed to it. And I sent an email to Mr. Jendrick that day, I think tentatively agreeing to it, and prepared an agreement. The draft settlement agreement was sent to him on August 9th. And again, at that point, I had never heard anything from Mr. Jendrick that there was any question about this agreement. He said, we'll do a walkaway. My client said, okay, on Monday, the 17th, August 9th, I sent the written agreement to him. And it was 2 weeks after that, when I followed up, was the first thing I ever heard that there was a question.
So his conversation with you about the walkaway occurred in July?
July 14th was the date that he called me and said the appellant would do a walkaway. Yes.
And it was not until August when you responded saying that your client had agreed?
No, I emailed him on Monday, July 17th, and we canceled the hearing that was set for July 18th.
Okay.
Our motion for summary judgment was set for the 18th, so we canceled the hearing based on the pendency of the settlement agreement, and it was on me at that point to draft the written agreement, which I did. I did send that to him on August 9th. He sent revisions back to me thereafter, which were then accepted. Again, this went on. It was September 13th that he sent revisions to the written agreement back to me, formalizing the walkaway agreement. There was at that point, no one had ever said. So we're talking about from July 14th to September 13th. We now have an agreement that's gone back and forth with revisions requested by the appellant's attorney. At that point, still nobody had said she wasn't going to sign it or she didn't want to do it. We were moving forward with the settlement at that point until she simply, after September 13th, when the appellant's attorney's revisions were accepted, after that point, when she simply would not sign it.
I do have one additional question, if I may. Mr. Brown, I'm trying to put together all these pieces to this puzzle, and it appears that your hearing was in September of 19. Then there was an order entered in February of 20 on that hearing, and it said those rulings that the court was referring to will be memorialized in a separate order. The next order in the record is the order from a hearing in August of 2020. Did any other order transpire between those two times?
If the court will bear with me just 1 second, I can look and confirm. There was a memorandum order regarding a phone call in which the court said that he was going to reject further briefing and was going to make a ruling.
I guess what I'm specifically looking for is the additional order contemplated in the order entered by the court on February 19 of 2020, which that order says those rulings will be memorialized in a separate order.
I apologize for the delay. I'm just trying to confirm.
That's fine.
Okay, there's the February 11th. I'm sorry, 2020 order. There was the February 12th, 2020 order in which the court denied further briefing. And then there was the February 19th. I believe that the next order was the next one that I have in my record it was the order denying the motion to alter or amend.
All right, thank you.
All right, we will hear from the appellee. Excuse me, appellant in rebuttal, I'm sorry. You're muted, Mr. Reams. There you go.
If I understood Mr. Brown to say that the case was settled on July 14th, I must disagree. Mr. Brown's testimony at trial was that the offer was accepted sometime between July 17 week when he communicated with his clients and August the 9th. I think there was a question about what the trial court based its finding that it was the settlement. There was an email at 3:15 from Mr. Jendrek to Mr. Brown on July 14. Just talked with Linda, and I think she will go for a walk away. That is apparently what the court thought was a settlement when the settlement occurred. But as we have said before, there was a phone conversation at 5 o'clock after the text message where Mr. Brown asked, "Is that an offer?" The offer was not communicated. This was on a Friday, the 14th, until Monday of the following week. And exhibit number 7 to the trial is an email from Mr. Brown to Mr. Jendrek, July 24th, 2017, on a different note, Mark. I do have consent from my people to a walkaway settlement so long as the release is general and unconditional. And that raises another point we have on appeal. Even, we say that there was no authority to even extend the offer, but even if it were, this email varies the terms of the quote walkaway offer. And the terms of the settlement agreement were a particularly important part, it seems, because even the next month, Mr. Brown sent an email to Mr. Jendrek saying that he had not obtained his client's approval to some changes that were suggested. Again, going back to the text message, and Mr. Brown says that it was not in discovery, was not available on Mr. Jendrek acknowledged receipt of a communication in an affidavit filed over a year prior to the hearing in September, and Mrs. Dawson testified or filed an affidavit saying that she had sent a text message to to Mark Jendrek, And also was in the record for a year prior to the trial. So this was not something that was sprung at the last minute. Just briefly addressing.
Let me ask you a question, Mr.
Yes, sir.
Reams. According to Mr. Brown's argument a moment ago, from July the 14th, when this settlement agreement was, when it suggested that it was entered, through September the 13th, there were documents going back and forth. There were revisions suggested, revisions made. Were you involved in this case during that interim? I'm just trying to figure out who had authority to do what during this period of time that this settlement agreement was being shuttled back and forth.
I was involved to the extent that I had agreed to represent Ms. Dawson and review the case for her. She had employed a forensic accountant in Asheville, North Carolina, and her affidavit is also a part of the record. I think it's Exhibit 10, and we were awaiting the results of her report and analysis to do the evaluation. I was not involved in negotiations that were ongoing, didn't know that they were really ongoing. These communications were ongoing between Mr. Jendrek and Mr. Brown.
Okay,
So,
let me ask you a follow-up question here, and that's this. Obviously, you didn't have any communication with Mr. Brown at this juncture. You were talking with your client, I assume, and you were also talking. Well, was Mr. Jendrek apprised of what was going on, and your involvement and the forensic accountant's involvement in this?
I think Mr. Jendrek knew that there was a forensic accountant reviewing the case. I think he communicated that to Mr. Brown somewhere in these negotiations.
Well, and I didn't ask that appropriately. I'm sorry. What does the record reveal about your involvement and the involvement of the forensic accountant during this period of time?
The record has the affidavit of the forensic accountant. The record indicates through emails, my name is mentioned in some of the emails specifically. The text message mentions that another attorney has been involved. And I'm looking to see if it mentions my name specifically. Yes. The text message sent at 3:50, Mark, I called Scott Reams' attorney to tell him about our conversation. As far as me being officially involved with a notice of appearance, I had not during this time frame. These negotiations were ongoing. However, it was known to both, at least certainly Mr. Jendrek knew it. At some point, Mr. Brown became aware of it. He had sent a text message that was part of the record to Whitney, I can't remember her last name, one of the principals with the defendant, that they had received a calls from a couple of attorneys on behalf of Ms. Dawson. So there was knowledge that she was seeking an attorney. There's some reference to those attorneys in the email. There are some in the text message and email, some reference to me specifically.
Okay. All right.
Let me ask you this, Mr. Reams. The accounting malpractice resulted in Ms. Dawson underpaying her tax liability. Is that right?
Oh, she paid, or the estate paid, over $100,000. The defendants paid $300,000, and there was a refund of $100,000 whose money that was would have been an issue in the lawsuit on the accounting malpractice. Ms. Dawson, the plaintiff, had employed professionals and did the work to obtain this refund. So if there were issues as to who would be entitled or how that 101,000 would be credited.
Okay, all right.
All right, thank you, gentlemen. We appreciate your argument. You've given us some things to think about. We will endeavor to file an opinion at the earliest possible time. We again appreciate you participating via Zoom. Mr. Hibner, if we have nothing further, you may recess court for the day.
This honorable court is now adjourned for today.
Thank you, gentlemen.
Thank you.